All right, let's talk about something that affects every single one of us here in Washington. What happens to your stuff after you're gone? When you really boil it down, you face a fundamental choice. It's actually a pretty simple one. Are you going to make your own plan, or are you going to let the state make one for you? Let's break down what that choice really means.
Seriously, think about it for a second. We all work hard to build something, to have something to show for our time here. But what happens to all of it when we're no longer around? Well, as we're about to see, the answer to that question completely depends on whether or not you've made a plan.
So you've basically got two options, two paths you can go down. Path number one, you're in the driver's seat. You make the decisions with a last will and testament. But if you don't have a will, you're automatically put on path number two, where Washington's laws, the state's default plan, kick in. The legal speak for that is intestacy. Let's explore what each of these paths actually looks like.
Okay, let's dive into path one, creating your own will. This is the you're in control path. It's all about empowerment, making sure your choices and your voice are the ones that matter when it comes to your legacy.
So what is a will, really? Think of it like the ultimate instruction manual for your stuff. It's the legal document that tells everyone exactly how you want your property, specifically what we call probate assets, like a house or a bank account just in your name, to be distributed. This document is your superpower to override the state's generic one-size-fits-all plan.
And you know what? You might think this is super complicated, but in Washington, it's actually pretty straightforward. You just need these three essential ingredients. First, it's got to be in writing. Second, you have to sign it. And third, you need two competent witnesses to watch you sign it and then sign it themselves. That's it. Those three simple steps are what give your instructions real legal power.
But here's the thing, a will is so much more than just a list of who gets your stuff. Of course, you get to choose exactly who gets what. But just as important, you get to appoint an executor. This is your trusted point person, the one you pick to manage the whole process. And let me tell you, that one decision can be a total game changer for your family. It can prevent so much confusion and potential conflict down the road.
Okay, so that was path one. Now, let's look at what happens on path two. What happens if you don't create that instruction manual? Well, that's when the state of Washington steps in and says, don't worry, we've got a plan for you, whether you like it or not.
And there's a legal word for this, intestacy. It sounds fancy, but all it means is that you passed away without a valid will. Simple as that. And when that happens, the state's official rule book kicks in, and its formulas automatically decide who gets your property. It's totally impersonal, a one-size-fits-all solution. So what does the state plan actually look like? This table gives us a quick glimpse. And honestly, some of these outcomes can be really shocking. Check out that second line. Say you're married, you don't have kids, but your parents are still alive. Your spouse only gets 75% of your separate property. The other 25%? It goes to your parents. Now, for a lot of couples, that is not what they'd want at all. And that's the whole point, right? The state's plan is just a rigid formula. It doesn't know you, and it can't guess what you would have wanted.
Okay, now before we go any further, there's a huge concept we need to talk about. It's like the golden rule of Washington property law, and it affects everything, whether you have a will or not. It's called community property.
Here's the absolute key thing to understand. In Washington, pretty much any asset or income earned by either spouse during a marriage is considered community property. This means you both own it 50-50, right from the get-go. Now, this is a big mental shift, so listen closely. Your spouse isn't inheriting their half from you. They already own it.
So let's break that down. Community property, that's the stuff you build together during the marriage. Your paychecks, the house you buy with those paychecks, all of that. Separate property? That's what was yours before the marriage or anything you got as a personal gift or inheritance. And here's the punchline. Your will can only give away your separate property and your half of the community property. That's it.
50%. That is the magic number. Your surviving spouse automatically, no questions asked, owns 50% of the community property. It's their vested property right, and a will simply cannot take that away.
This quote from the legal text really drives the point home. It basically says you don't have the legal power to give away something that isn't yours to begin with. And your spouse's half of the community property? Well, it isn't yours to give. It's an absolute ironclad rule.
All right, I know you're probably thinking, with all this talk about property and assets, the big question always comes up, what about taxes? It's a huge concern for a lot of people, so let's tackle that head on and put your mind at ease.
Take a look at this number.
For 2024, the federal estate tax exemption is $13.61 million. And get this, that's per person. Let that sink in for a moment. An individual can pass on over $13 million before the federal government even starts to think about taxing their estate.
So, what's the bottom line here? It's simple, really. For the vast majority of us here in Washington, federal estate tax just isn't something we need to lose sleep over. The real action, the thing that really matters for most families, is making sure your property goes to the people you want it to go to.
Okay, so let's bring it all back home. We've walked down two totally different roads, right? The one where you're the architect, drawing up the plans with a will, and the default road the state paves for you if you don't. Let's just quickly recap why picking your own path is so incredibly important.
When you make your own plan, the power is all yours. You pick your heirs, not some government formula. You name the person you trust to be in charge, not some stranger appointed by a court. You get to bring clarity, to head off family fights before they can even start. At the end of the day, you make sure your wishes are what count.
Because really, that's what this is all about. A will isn't just a dry legal document about money. It's about your intentions, your values. It's your final message, a way to show what and who mattered to you. It's truly a final act of care for the people you love.
So, I'll leave you with this one question to think about. What do you want your legacy to be? Is it going to be the one you carefully designed yourself, or the one that's just left up to a state rulebook? The choice, as they say, is all yours.